I am Eric Friedman. I am Assistant Executive Director for Public Affairs with the CFB. And so, by way of introduction, we are here today to inform our post-election review, which will result in ultimately, a set of concrete recommendations to strengthen the campaign finance program. The board's main legislative recommendation after the last citywide elections, made in the wake of the Citizens United decision, was a proposal to require disclosure of independent expenditures in city elections. The Charter Revision Commission put this question to New Yorkers in the fall of 2010, and 84% of voters approved. So last fall, New York City conducted its first citywide elections under the new disclosure rules, and we saw the flood of outside spending that many of us expected. Nearly $16 million in independent expenditures were made in races across all five offices that we covered. So to the extent our program aims to ensure that the intent of the voters is expressed clearly and not drowned out by big money, the question that we have to address is this: does the rise of independent spending in city elections threaten that goal? It is impossible to ignore the impact of outside spending that, in some cases, doubled or tripled the spending limit for individual candidates. Even still, and this point is illustrated in the charts we've distributed today for the hearing, in the aggregate, public matching funds outnumbered independent spending by a rather significant margin. The disclosure also meant that information was available via the CFB website about who the funders were and how the money was spent. There was no so-called dark money in this election. The site provided voters with images of the advertisements and the mailers that went out, which is yet another tool in holding those spenders accountable. Still, I know we're going to hear some suggestions about how our disclosure requirements can be refined even further to make them even more useful to the voting public, and we have with us an outstanding panel that I think can help us explore this issue from just about every angle. We have Councilmember Brad Lander, who is sponsoring legislation you've heard mentioned already, and I'm sure he's heard from some of his colleagues about their experiences on the campaign trail this past year. We have Josh Gold, who in his role with the Hotel Trades Council was involved in one of the independent expenditure efforts in the general election, and he, I hope, can bring the outside perspective to this discussion about the place of independent spending in our system. And Susan Lerner of Common Cause New York. Common Cause used the independent expenditure information that was disclosed with us to do a rather thorough analysis of the impact of independent expenditures on these elections, and she will, I hope, talk about some of their conclusions. So why don't we start with you and come back this way?
Start with me?
Sure.
Okay, good enough. I wasn't expecting that. So, what we saw with independent expenditures, aside from one aspect, I'm sorry?
You'll learn that you have to actually put your face right up against this microphone to be heard.
Well, first of all,
it seems I have to turn it on. So that's step one. Okay. So yes, we did, and I have to say that having the Campaign Finance Board disclosures to work with was a pleasure. And I think that certainly the effort to have clarity regarding independent expenditure baseline disclosures was extremely important. I will leave to Brad the discussion of the top 5 bill that we've worked with him on. I will say that Common Cause has worked with several of the states that have passed similar legislation. California was the first. We helped to write the top 5 bill in Rhode Island. And there are similar disclosure laws which are in place in Alaska and in Connecticut, and we helped to write the Connecticut law as well. But what we saw was a very interesting pattern, and I'd like to focus on one way in which we think that the New York pattern for independent expenditures illustrates yet again, as if we needed another illustration of why the majority of the U.S. Supreme Court was wrong in Citizens United, in saying that independent expenditures couldn't possibly have a corrupting influence. And that is because we saw at the council level and then in the general election mayoral race a phenomenon that seemed to be the use of independent expenditures to what we call curry favor. Independent expenditures on behalf of council candidates who had very clear ideological positions which were not supportive of the position of the independent expendor. And I'm talking specifically about jobs for New York. Spending close to, I think it was over $7 million out of the $10 million that they raised to support candidates in major part who were very progressive and who took positions which were not supportive of the real estate industry's positions. To us, it seems to be a way in which to gain access and to be sure that they had a more favorable reception than they would have had if they hadn't made those expenditures on behalf of people who are not ideologically aligned with them. At the general election level, we saw an interesting phenomenon that seemed to us to be almost an apology by Democratic organizations which backed Democratic candidates at the primary level who were not chosen by the voters. And it seemed to be a bit of a guarantee, sort of an apology. We're sorry we backed the wrong horse. Don't be angry at us. Here's $500,000 in independent expenditures, even though you're in the 70 percentiles in the polls, just so you know we're your friend. This to us is a matter of concern and I think highlights what's really wrong with Citizens United. But I'd like to also talk about a phenomenon that we've seen before, but we're really seeing in this last election cycle, and that is confusion about the role of political consultants. And a situation that because of the Campaign Finance Board's disclosure requirements became obvious after really in the end of the cycle and as everybody looked at the disclosures in detail, and that is consultants who were representing a particular candidate in a city council election district who were also providing consultant services to an independent expenditure opposing that candidate. It's one thing if you have a consultant who is helping the candidate, who is working for the candidate and helping an independent expenditure which supports the candidate and questions of collaboration come up, and there are procedures which the Campaign Finance Board has been working to develop in terms of firewalls which deal with that situation. But what do we do in a situation where there seems to be no basic sense of morality in the consultant community? And it seems to us a common cause that we should be looking at the legal community, where you have a situation where you have paid spokespeople who can find themselves in conflict positions with clients who are taking diametrically opposed positions. And there is a well-worked out procedure with a ethical set of standards for what is or is not a conflict and a procedure for waiving the conflict, or at least disclosing it. And we would suggest that the Campaign Finance Board should take a look at the possibility of promulgating some basic guidelines, ethical standards for consultants, and perhaps consider having a requirement that if public money is going to be used to pay a consultant, that the consultant has to subscribe to the course of conduct, which at a minimum would require disclosure to the candidate and to other clients if they were taking positions which make both of their clients look bad and which make the consultants look unethical. That's number one. The other area that we were concerned about and that we mentioned in our testimony and that I want to bring up is the question of the interplay between the city's campaign finance limits and the ability to open an account at the state level. And this came up in the context of the so-called race, because it wasn't really a race, but it ended up being a campaign for the person who would be chosen as the next speaker. And again, it's the involvement of consultants and the desire to have the assets, the resources to pay consultants. And it's not something that is contemplated by our campaign finance system, and yet we had individuals who wanted to raise money and pay consultants to advise them as how best to position themselves to be the next speaker. And as I understand it, we're advised that the appropriate thing to do was to start a committee which would be able to raise money under the state guidelines, even though they agreed not to raise more than the city limits. And it concerns us as a way around the campaign finance system of New York City. And we suggest that the Campaign Finance Board should consider the idea of an office holder account, which is an account which various states have used. For instance, in Arizona, with the public financing system, they allow office holder accounts, recognizing that office holders have unique expenses, which they shouldn't be expected to pay out of their own pockets, and yet are perhaps not really campaign related, and we shouldn't encourage people to run campaign accounts for 4 years while they're in office, but that there is a special designated account which allows you to send birthday cards, which allows you to send condolence flowers, which allows you to hire a consultant for something internal, that would have its own limits and that would have its own guidelines. And that could be regulated within our city system, so we would not have this duality where an elected official under the city system is encouraged or finds it necessary to open a special account under the state system, even though they aren't really running for office for a state office. So we think the issue of consultants is one that we should be talking about more, and that we look forward to exploring with the Campaign Finance Board in the future.
Councilman?
Good afternoon, or good snowy afternoon. I'm glad that this, unlike all our council hearings today, that this was not canceled. So thank you guys for sticking around, and everyone who's attending here. I'm New York City Councilmember Brad Lander. I represent the 39th District in Brooklyn. And I'm a longtime fan and supporter of the New York City Campaign Finance Act system. Was pleased to do an amicus brief in the Ognebeni case, in defending our system against some of the challenges that flowed after the Arizona suit, and was pleased to see that many of the most important provisions of the law survived. But I don't only come as an advocate of good government, though I'm surely an advocate of good government. In this case, I also come as a participant in the system, and someone who, in the last cycle, sought to find ways to advance a point of view appropriately through the campaign finance system. So before I talk for just a minute about our experience with Jobs for New York and with Intro 1193, the reform that I'm proposing and that I hope will be moving through the New York City Council to require on communication disclosures about independent expenditures, I do want to just give you that perspective, because the challenges that we faced in responding to Jobs for New York came in a particular context. A number of my colleagues and I in the City Council, as you may know, 4 years ago when we arrived in the City Council, formed the Progressive Caucus, members of the body meeting together. And we then wanted to form an appropriate vehicle outside of the body to be able to do electoral work together and support City Council candidates in the 2013 cycle who share our point of view, be able to grow the ranks of the Progressive Caucus. Perfectly appropriate thing to do. So we reached out to the CFB to try to ask about what the most appropriate way to do this was. And we were informed first that we could not join a second authorized committee, that candidates are only allowed to be in governance of one authorized committee per cycle, and that we therefore couldn't be part of a second committee. So right away, we wouldn't have the ability to be involved in an independent expenditure in a governance capacity. And what we decided to do with the advice of the CFB was to form an entity that we set bylaws up for and worked on disclosure requirements with the CFB, called the Progressive Caucus Alliance, which worked together to, in fully transparent ways, as an intermediary fundraiser, all covered by donation limits and therefore by the candidates' expenditure caps, and with every expenditure of that entity coming from our accounts and fully disclosed to the CFB. So essentially living fully within the expenditure and contribution limits in a fully coordinated way, fully disclosed in every way, both on the contribution side and on the expenditure side. So we found a way to say we're a set of people with an appropriate point of view to advance in an election cycle, to try to support candidates, to be able to do that together, to be clear about it, to announce it. We had a website, a political point of view, to advance candidacies. And we were proud to do that in a way that was coordinated, that lived with every rule of the system, that wasn't independent, and didn't require, the badly distorting impacts of blowing the caps in particular and distorting each race with money that independent expenditures require. So I just say that because we didn't approach this as a group of people saying it's not appropriate for interest groups to seek to advocate a point of view and support candidates in an election cycle. We approached it as people who believe that's what our electoral system is for, and the rules exist to help us do that. So it is not simply good government is not simply let's not spend any money, let's not enable people to advocate a point of view. The good government is people have a point of view, let's make sure they play by the rules, and we can keep the level playing field as much as we possibly can. Now, we knew we might face independent expenditures, and as I mentioned earlier, we actually had thought about, should we set one up? Now, we were informed that as elected officials in particular, we couldn't do that. So it wasn't a choice that was available to us, but we still never thought that we would wind up in races essentially in competition with candidates who were able to have spent on their behalf 3 times as much as the candidates that we were supporting. So every candidate that we were supporting, the money we were helping them raise was simply going to the $168,000 that they're allowed to spend under the system as participants. And all our work was channeled into helping them with that piece of the election. And yet, in races where Jobs for New York was on the other side, there was the candidates, the other candidates were spending that $168,000, but Jobs for New York was in some cases spending 3 times that amount. And of course, there's no limits at all. They could have kept spending and spent 10 or 15 or 20 times that amount. And I fear that in some ways we'll look back and think 2013 was a trial run, and that even what seems like a dramatic dwarfing of what you can do on the participating side, that we'll wind up with things that are far more than that. One side concern that raises, that unfortunately is what Citizens United does and not what we can address, is we will wind up in a situation where candidates thinking about whether to participate in the matching system at all have to ask the question, does it make sense for me to participate? The matching funds are great, I want to be part of this good system, but if my opponents are able to have 10 times as much spent on their behalf, what do I do? So that's one flag, and again, it's hard for us to figure out what to do about it, but that's in part why we're here. So I know that you've had some wonderful materials prepared. I want to give credit to the staff of the CFB who really looked at, put online so everyone could see, and then did follow-up research to really focus on what the consequences and harms were. In council races in particular, one thing that data showed was the ratio of independent expenditure money to candidate money. So even though there was a lot of money spent, independent expenditure money spent in the mayor's race and some of the other citywide races, it was much, the ratio of independent expenditure money to candidate money in the council races, especially where Jobs for New York spent, but others as well, dwarfed the ratio in the citywide election. So the impact of independent expenditure money was far greater. So those races were awash in IE cash, and it had a number of other really negative consequences as well. So in the case of Jobs for New York, the vast majority of the contributions came from LLCs, mostly real estate LLCs, largely raised in $50,000 and $100,000 chunks. So while candidates are raising in at max $2,750, and if matching only on that first $175, and if people are doing business with the city, $250, the independent expenditure money was being raised in $50,000 and $100,000 chunks. Much of it from people who are in fact doing business with the city in their individual capacities, but still through their LLCs, under state law, under Citizens United, able to give in those very large sums, even if they are doing business with the city. Very strong concerns about pay-to-play, again, a thing that we've addressed so well in the campaign finance system as a result of the doing business limits, the disclosure, the non-matching. And there was a great report done for the '09 cycle that I'm guessing you'll probably do again for the 2013 cycle that looked at what a strong effect that had reducing the percentage of contributions to council candidates that comes from people doing business with the city, the most direct pay-to-play, the most narrow concern around just direct corruption that you could possibly have is, are there people who are doing business with the city who are going to expect to come before you and ask for their business to be impacted as a result of contributions? So the doing business limits that were put place in the law between the '05 and the '09 cycle had enormous impact, as you saw in that 2009 report. I think we'll see it again in 2013. Unfortunately, they're dramatically undercut by independent expenditures, which let those businesses give in these unlimited ways. And it's not only, I think, as Susan says, what happened in the speaker's race and what sort of access, but you know that throughout the next 4 years, those individuals are going to be in front of council members in ways that we now really can't track. And then I'll just add, in addition to that, one other thing that we saw in council races is that the negative campaigns, the negative ads, the tenor and tone, in some cases xenophobic, in many cases just supremely hostile, went beyond what I believe would have happened with the ways candidates attack each other. And I know there are people concerned about the negative ads even with direct candidate spending, and Councilmember Gorodnik has a good bill to make sure that candidates put their names on their pieces, and I wholeheartedly support that legislation. But when you've got spenders who aren't, really implicated in the race in the same way, independent expenditures just make it so much easier for people to run a scorched earth campaign policy. You essentially are taking millions of dollars, giving it to a consultant and saying, do whatever is necessary to win. None of us will really be remembered or have any implications in the race. So that's all the negatives. You know them all. I'm only telling you things you already know. And unfortunately, most of that is allowed by Citizens United in ways that are very difficult for us to have an impact on. We would like, for example, and I had proposed earlier, just to try to close the LLC loophole for independent expenditures, as we've done with the system for direct expenditures. And unfortunately, there's obviously a lot of questions about whether that would survive legal scrutiny. It would be great if the state would close the LLC loophole, at least for direct contributions at the state level. I know Common Cause and others, and the Moreland Commission itself identifies that. And it would be great to do that on independent expenditures as well, but there's questions about whether that will survive court challenge or not. But the one thing I'm almost certain we can do, and it would have meaningful value, even if it can't counter all of that, is just require that the spenders in a real meaningful way disclose that it is an independent expenditure and sign their name on the communications that they are sending to voters. So I, with help from Common Cause and a number of other good government groups, introduced at the end of the last session, and will be reintroducing in this session, Intro 1193, which Susan called the top 5 donor disclosure rule, or some people refer to it as on communications disclosure. This law would provide that on independent expenditure mailings, as well as independent expenditure TV or radio ads, there be some identification and clarity that it is an independent expenditure, not covered by our campaign limits and the rules of the Campaign Finance Board, and that you disclose the top 5 donors to the independent expenditure and provide a link to the website if people want to learn more. If you knew what Jobs for New York was, or if you knew to go look at the CFB website, you could get all the information that you needed to understand who was behind those mailings and what interests they had. But if you simply received in your mailbox mailer after mailer after mailer attacking a candidate or supporting a candidate, you really had no way to know. Jobs for New York sounds like a great thing. We all want jobs for New York. You'd have no way of knowing that it was a PAC created by the Real Estate Board of New York, that its donors were LLCs who gave in $50,000 to $100,000 chunks that represented real estate developers throughout the city. You just wouldn't know it. And that is what we saw happen as we were knocking doors, as candidates were knocking doors. For the most part, people thought that it came from the candidates being supported. Of course, that's what you would think if it was a positive piece. You were inclined to think, and so quite a few of the people who have signed on or indicated they're going to sign on to the new bill were candidates supported by Jobs for New York who found that they didn't want to be associated with it, that as they were knocking doors, people were saying, why are you sending so much mail? Your mail is, so negative and nasty. So that's what voters think, is that it comes from the opposing campaign or from the supporting campaign. They have no way of knowing what's behind it. So at least one thing that we can do, and that I hope we'll do through this change in the law, is to, again, I guess you can call it bringing it out of the dark. It's already on your website, but making sure that when people receive the mail or see or hear the ads, that they have some ability to understand who it is that's behind it. Thank you.
I just wanted to point out that starting at page 9 of our testimony, we have mock-ups of what the top 5 disclosure could look like on the actual mailers that we were able to access because of the Campaign Finance Board through the website. Yeah.
Thanks very much, Susan, Councilman. Josh?
Thank you very much, Josh Gold, the political director at the Hotel Trades. Josh Gold, the political director at the Hotel Trades Council. I had a unique opportunity this cycle, and so I'm happy to come speak with you. I worked during the primary election on coordinated directly with campaigns, and worked directly with campaigns, and during the general election on the independent expenditure side. I've been in this room. I knew you guys were giving it that one. I've had plenty of strong conversations with the board and their staff over the past couple of years, but I think that by and large, I hope you understand and know that my union and me myself really appreciate the board and think that the program is doing a great job, and comparing to other similar programs that we work with, really tries to take into account the considerations of spenders and of campaigns and everybody who's involved in the system. So I really think that this is a phenomenal program that needs to be protected, and although we do disagree from time to time on certain things, that it's all in the betterment of making sure that the program stays strong and powerful. And I wish that all of you who are here would come lobby the state to make sure we have a similar program up at the state level as well, because we feel it does a lot of good for elections in general and in principle. I'd say, on disclosure, I agree with most of the things my colleagues have said. I have a couple suggestions on some stuff they talked about. I'd really like to thank Eric first for talking about dark money. I think a lot of the media coverage around some of the IE spending called it dark money. Because of the good work that the board does, the money isn't dark. Beyond the LLC problem we talked about, the money isn't dark in New York City, which is unusual for this country and for this state, that we have access to know who's spending. And if you have a Google account, you can probably find out who owns those LLCs. And so I think it's really important that you continue to emphasize that the program here in New York does not allow for dark money here in New York City, and we have to make sure that we continue to push that. I'd say there are a couple of issues that I found working on both the coordinated side during the primary and then on the independent side during the general, is that one of the concerns, we talked a lot about disclosure of independent spending, something that I strongly believe in. The other concern is about coordination, not in the member-to-member angle that I've talked to you about numerous times, but in terms of IE coordination with campaigns. And I think that there's a line that we have to worry about, because as a campaign professional who works on a lot of campaigns, in order to find out what IEs are doing, my first source is the New York City Campaign Finance Board's website. I can find out, I can look at a mailer and kind of guess who they're targeting. I can look at how much they spent and kind of guess how many, people they've sent the mail out to. I can look at ad buys and figure out, using the FCC website as well, figure out where, their ads are being placed and how much ads they're placing. So I think, the more disclosure, the better, but I also want to make sure that you understand that there are signals that can be sent between parties that you can't do on an email because you can't coordinate, but you can use the Campaign Finance Board's very in-depth and very important website to let the other side know what's going on and how you're spending your money, and that's not something that we want. And I'm hopeful, I'm sure, I think that's not something that any of you all want. I'm hoping it's not something that you all want. I want to just point out a couple of things that we talked about here. I actually disagree. I think you're going to see a decrease in spending 3.5 years from now, simply because of what you talked about, the currying favor, the amount of money that was spent. If you look at the results that some of the IEs had, they weren't really that great. One of my favorite tools about the CFB's website and seeing all the IE work is I can see how bad some of the consultants are that are sending out mail and creating TV ads. And I think that a lot of spenders are going to realize that this wasn't really money well spent, and you may see a decrease. I'm hopeful that you see a decrease in spending the next time around. I'd say that, we did do an IE called New York Progress in the general election that was probably the largest spender in the general election. I don't remember the exact numbers. I think that IE was set up before that IE was set up in case there was an actual race, and when there wasn't, we decided to spend the money anyway, but it wasn't set up to necessarily curry favor at the, I can't speak for every single donor. There was plenty of people I raised money from, but the purpose of it was set up because there was a chance there would be a race in the general election, and we raised money for that, during what would have been the runoff period, and got commitments for it and decided to go ahead and spend it, and that is something you can ask questions about, but we did raise money for that with the possibility of a race. I'd say, one thing that the board needs to take into account is that usually you buy your TV ads when you get your money right away, even before you make your ads or even know what your ads are going to be about. So we bought the TV ads. I think we bought the space 6 weeks before we knew there was, you buy the week one, which is the week right around election, the week right before election day. You buy that first and you move backwards. So week one is the first week, going backwards from Tuesday, and then week two is the next week backwards. And so you buy that really, really early on. And so once you buy that, you don't really have an opportunity to unbuy it. And so, once you see the poll, once somebody's winning by 60%, you may want your money back, but there may not be an opportunity to do that. So, but I would say that there are definitely spenders who spend in order to influence decisions down the road, and that's a real big pay-to-play problem. It's something we have to watch out for, and I honestly believe that people aren't going to get what they think they're getting, and that's going to limit the amount of spending down the road. I would say in the council races, independent expenditures, although primarily because I think all the consultants aren't that great, didn't really have that much of an impact if you look at the races where they spent the money. I think you guys actually showed that in one of your reports that came out a month or two ago. I'd also say that there is a potential for impact, especially with the negative spending. So I would explore, and I'm not sure about how the Arizona case or any other case, if it allows for this, but lifting the cap based on the independent expenditures that take place. It's not allowed. So in any event, if there's a way to legally lift the cap based on a level of independent expenditures, I think that's, there's not. Oh, well. Another idea.
I did put a request in to draft that bill before the lawyers.
The lawyers said, well, Brad and I are smart guys. We'll try to think about a way to get that. Another thing I would say is spending disclosure, whether it's the top 5, and I have another idea on spending disclosure, will very much limit negative ads. As a spender, as a union, we very rarely take out negative ads because you never know the results of an election or the next one or the one after that. And the negative ads, if your name is on that, that's really not good practice if you're lobbying in the future, or if you're trying to work with candidates down the road on other issues. So I think that whether it's top 5 or another kind of disclosure, that will limit the barrage of negative ads, which really the mail this cycle was above and beyond what I've seen in the city's elections. It reminds me of purple, blue state, red state battles in the rest of the country, and so I think that really will help to do that. I already mentioned that the consultants are bad. Sorry. What I would add to Brad's bill about spending disclosure is I believe you should encourage or force, if you can, every independent spender to have a small URL, not like a www. XYZ / 100 different things that lists all their spenders. I think that there's plenty of ways to hide who the top 5 are, and people are just going to get around that. So rather than rather than do that, make a minimum. I know that my IE during the primary, my union's IE during the primary, that didn't have any, thing to do with during the primary election, had a warning about the size of their font, and we expanded the font after we got the warning. But you should have a very large font that says, "See who bought this ad here," and and a link to who paid for the ad with a small, one of those tiny URLs, so that everybody has the opportunity to see who paid for the ad, and not to the CFB website, which is really great for those of us in the business, but for a one-page website that just lists the people and how much money they spent, that can be updated on a regular basis like a filing, so that people can't hide money at the very end. So that would be my suggestion on that. I would like to ask the board or the staff to on a separate topic, just while I'm in front of you, is to have further conversations on how the new rules around member-to-member and coordination impacted or chilled some speech this cycle. And I think there are ways that we can work together, as we have in the past, to make sure that those rules are appropriate. And so I would encourage the board and the staff to meet with membership organizations to discuss how we can better have those rules and talk about some of the challenges this cycle. I didn't prepare anything really, but I would love to here to talk more about my experience either on the campaign side during the primary cycle or on the independent spending side.
Thank you, Josh, and thanks to the panel. I think between the three of you have something like a 360-degree view of the issue. So I appreciate you being here. I actually just want to jump off of something that Josh said and kind of put this question to Councilman Lander and really to all of you. So if you look at what happened during the last election, some of the candidates who were supported by the largest independent expenditures actually lost their elections. If you look at the mayoral race, the candidate who got the largest IE in support of his campaign didn't win the primary. If you look at the really most competitive council races, some of those races where jobs for New York spent heavily, 250,000 plus, backing candidates who ended up losing. So does all this suggest that voters are smart enough to figure this out on their own? Does it suggest that the Public Match Funds program is actually doing what it's meant to do?
I mean, my answer. The consultants are bad, but anyway. Sorry.
We know what Josh is
last
doing
time
next. You're
Yeah.
going to start a consulting business.
No.
Well, I was going to say, I think that it does show that the Campaign Finance Board and the New York system, the matching fund system, is doing its job, and that's actually the argument that we make to our state legislators, and Josh's call out to the fair elections effort is much appreciated, because really the only protection under the current system and the only way to respond with independent expenditures is knowing that you have a baseline of funding with public funding, and that you are able to show the voters that you trust them first and foremost. So I think it is a strong tribute to the campaign finance system.
And I'll agree, and maybe I'll just go with your other explanation. I do think, and in a couple of the races, I spent enough time on the ground to be. It's patronizing to say pleasantly surprised, but I did find a lot of voters who were able to see through things and understand what they were getting and ask good questions about it and make decisions that were based on something other than the wash of advertising they were seeing. So that is heartening. It does speak to the value of the system, but I don't think it's a reason for complacency either. Enough money can buy good consultants instead of mediocre consultants. Enough money can do more focus groups, can do more testing. This is like, I think, folks, about any advertising. I don't know, I heard it put this way one time. We know that about 10% of advertising works. We just don't know which 10%. So we'll pay for the whole thing and hope that, the pieces of it that we do get through. There were definitely some races that were affected by the independent expenditures, and as time goes on and the consultants get smarter and are testing things, there are going to be more races where they are able to sway more voters. So.
I think it is perceived that some of the early negative ads in the mayoral race did affect the mayoral race. I want to go, because one of the earlier speakers in a panel this morning, which wasn't directly on the independent expenditures issue, but he touched on the independent expenditures issue, suggested that we require the identification not just of what I'll call the first level donors, but the ultimate donors, in the sense that the committee for a good New York, the donor is the committee for an effective New York. And he suggested that you really take it down till you got to an individual or a real entity, whether it be a union or a corporation or an LLC. By the way, he also suggested accompanying that with the ability to increase spending limits as a way to combat.
It's what we call the Russian doll problem, and actually there are some states that have tried to crack it. Washington has had a Washington State has had a long-standing disclosure requirement of C4 type advocacy groups having to disclose their donors, but not just at the top level, but the ability to go further to the ultimate donor. So it's something we're acutely aware of. It's where dark money can pollute even a disclosure system like the New York City system, and it's something that I'm happy to hear is being discussed because we have to be aware of it. In our testimony, we cite to some research which concerns us. There is some suggestion that voters find negative ads which come from a placidly named or attractively named committee to be more persuasive than negative advertising which comes from a candidate or a well-identified special interest. So the kind of disclosures that we're talking about on the top 5, the on-communication disclosure, I think are really essential.
I just want to add, I agree that we should find out who the donors behind the donors are, or the donors behind the donors behind the donors. I just want to point out that we be careful in how we craft such legislation. For example, my union has close to 35,000 members who pay 90 cents a month.
No, I think we're talking about going to the entity. It was clearly they were not talking about going to the members. Nobody was talking about that. It was going when you hit an actual entity that people, you know what the entity is, or you hit an actual person because it's the Koch brothers putting in $100,000. That's an actual person.
Totally agree with that. I just want to because I made a joke before, but I want to be clear because I already see Twitter remarks before. There are races in this cycle that were impacted, that I'm not going to name the race, or multiple races, that were definitely impacted by independent expenditure spending. No matter how bad I think some of the people were at doing what they were doing, there were definitely races that were impacted by the flood of money. And, I think that's, a very important reason why we need to make sure we're making everybody disclose who the spenders are.
So a couple of things on this. First, 1193, so one of the few areas where the existing CFB disclosures, even on the website, can be strengthened is at this point, because for Jobs for New York, you could only see the LLC list. Now, in the aggregate, that actually told you everything you needed to know. 41, Madison Avenue LLC, like you could see the list. But 1193 would amend it so that you'd have to disclose, not just in the on-communication disclosure, but in what you report to the CFB. There's some language here: officer, chief executive, the ability to get to the individuals behind. And we can look a little at whether the language we have in 1193 is right. Connecticut has another approach. So I think it bears some work making sure we take the best approach to getting to the individuals, that goes on the website, that as much as feasible, some of that is what's on the communication. I think Josh's point that enabling you to get from that communication to the rest of the information is important as well, because obviously you're not going to be able to list, so many people on a piece of mail. We do have a $1,000 threshold. So until you're giving above $1,000, you wouldn't be targeted by this. I think even there's a little more work to do, because if there were 100 people that each gave $2,500, I don't know which 5, you will have to disclose. So we have some work to do as we move this legislation forward to get these questions just right. And I'm not saying that we think 1193 has them all perfect, but I think these are questions we can answer as we move the legislation
And
forward.
also, in terms of Josh's concern that it be a website that's very user-friendly, Rhode Island, actually, in their bill, requires that the candidate for TV and radio ads have to maintain a separate web page that is just the necessary listing of who are the funders, and that's what shows up on the TV screen and is the URL in the radio advertising.
Add mail to that.
Yeah.
Is there any questions from
Hi, O'Brien Murray. Thank you for your time today for the panel. I have a quick question for each of you could probably address this. Susan, you mentioned the word firewall earlier on, and we're talking about disclosure, and if everything's disclosed, that's great. That's all part of the process. But how do you ensure when independent expenditure is truly independent? And I know during the campaign, you had an issue you brought up during the campaign. How do we address those issues during the campaign prior to an election so voters can make that decision? So it's really a two-pronged question for all three of you.
And actually, that's something that we have in our written testimony that, for sake of brevity, I didn't go into. We believe that there needs to be, a clear firewall procedure. I think that there are ways in which firewalls can be set up. As a recovering lawyer, I'm certainly familiar with the idea of firewalls within a law firm, and I know that Josh, I think, is in a better position to talk about the kind of firewalls which the unions and others put into place. I think that the CFB reviews that documentation, and I think that the disclosure forms, the disclosure that the CFB has up on the website where there is a firewall in place ought to have an asterisk like you have in a financial statement, right, that says asterisk. Well, this is subject to the following litigation, and we're not opining as to that, but an asterisk that says, this is an independent expenditure with a firewall that has been reviewed by the CFB, so that people know when that situation is in place and can be citizen watchdogs if they see something which seems to indicate coordination.
I have no idea whether this would pass legal muster, but if it were appropriate to require that any consultant being paid with matching funds is only in a race in one position, I think that would be a very reasonable rule, so that if you are, but even with the people's money?
It's something to explore. We've run into First Amendment problems periodically.
You obviously couldn't do it outside of the context of the matching funds, but it might be worth looking at if matching funds are going to be used to pay a consultant, that consultant is not in that race with an independent expenditure either for or against that candidate. That would be a very...
Well, you might be able to do it by creating a per se rule of coordination. It's per se coordination if you have a consultant who is a consultant to the independent expenditure is the same consultant to the candidate.
I find it, I understand that in some cases you have to allow people to have a definition of firewall, but for me, and I don't know, law firms, I have a certain amount, they need to stay clear of the law a little more than political consultants do. I don't think, I would not believe, and I don't think most New Yorkers would believe, that a political consulting firm spending for a candidate and spending for an independent expenditure on behalf of the same candidate are actually likely to respect the firewall. Even leaving aside some of the information that came in this cycle about just how close they were, I would certainly think that you could make a per se definition if you are a political, and if we could do that overall, great. If we could just do that with matching funds, that would at least be a step forward. So we can explore whether there's a change to the law that could, either your regs or the law, that could help with that.
Perhaps you could limit the people seeking profit. I'm sure, just trying to carve myself out here.
I understand.
And there are federal regulations which have been proposed, certainly I know at our national level that we support, that would say that if it is the same consultant, then there's a presumption that it's coordinated.
But it's not just a consultant's contact between them that we have to remember weighs into this. So if you're an independent expenditure and you then contacted the campaign or the employees in some way, it's no longer independent. And now with matching funds involved, there's issues.
I think no matter what rules you create, there are going to be people who find a way around. I can go meet somebody at the park and trade information with them. No matter what rules you create around it, you can make a rule. You probably legally can't, but that the consultant has to be from another state, and I can go meet them in another state and get the information I want. So I think that there are plenty of rules that we can try to make sure that we're keeping everybody. Limit coordination as much as possible, but for those of us who try to be good actors, and I have a team of lawyers that are in contact with these guys every day during campaign season, what you're ending up doing is creating an atmosphere where those of us who are trying to behave and play by the rules are spending literally tens of thousands of dollars to make sure that we are playing by the rules, and those who don't want to play by the rules are not playing by the rules no matter what we do. So, I think I'm all for trying to figure out how it's ridiculous that a consultant works on a campaign and then has an independent expenditure on the same exact race, just to make an extra dollar or two. I think that's, something worth exploring. But at the same time, setting up massive amounts of rules that are only really followed by those of us who want to play by the rules and go through great lengths to do it is not necessarily a solution that will solve all these problems.
But isn't it then become almost a simple rule to say essentially that you can't be both independent and non-independent? That is, that's a clear rule,
So-
and you have to choose one or the other.
Okay, so let me.
You don't have to spend any money on compliance.
I'm just trying to say this the right way, so nobody uses it against me down the road. But I'm saying that in situations where you're communicating with your own, it's tricky to have a rule that's that simple and straight when you're talking about membership organizations and other organizations. If you're saying that if unions want to talk to their members about the candidates that they endorsed, then they can't also spend independently.
We're not talking about that.
No, but that's what
Forgetting about member to member.
But that's where the problem becomes for us, right? That's the membership coordination thing that I know it's not part of this hearing, but that's a long conversation that that's where the firewall, most of the firewalls that have taken place have been done by the same 3 or 4 attorneys, and they've all been done for labor unions that are trying to stay on the good side of things. And I've worked with the staff, or had attorneys work with the staff over the past year, I don't know, in contact with the staff on almost a daily basis to try to make sure that we were staying on the right side of the law when it came to independent expenditures versus coordination versus member-to-member stuff. And I know we spent 2 years working on those. So I think that this is a connected issue, but I think it's worth a long discussion about what qualifies as coordination when it comes to member-to-member. That's a whole separate conversation. If there's a way to solve that issue, I think that that what you're saying makes sense. Talked like a lawyer there, and I apologize.
And I do think there's a difference between the consultants here and the spenders. Obviously, the spenders, the individuals behind Jobs for New York were perfectly free to donate up to the maximum limit to those candidates on the coordinated side, and then give on the independent expenditure side. So I think that in a certain way is more comparable
Yes.
to the to labor unions. I think what we're mostly talking about is on the consultant side, where this simple rule seems very straightforward, and that there's no reason not to
It
have
could
this.
come up in the other
I-
context, but I think it is a more complicated discussion.
I guess I will say to this point, and again, this is an argument with Citizens United, not an argument with anything here. I don't believe that they're any better if they're truly independent. So I think the idea that this sort of spending would be fine or okay or better if it were genuinely not coordinated is not true. Even if you. So that's the, it is the rule, making sure people follow it and using good definitions of it makes sense, but.
Okay. We actually are running real late, and we have a couple people who are waiting to testify. So, do you have an actual question, or you're going to make a comment, or? Okay, I can give you a minute because there are people
The
waiting and
independent
it's getting
spending,
late.
as far as my district race, polarized my district. It wasn't really good, and I think in the future, if you can tie these independent spending to force them to tie themselves to a candidate, whether it be mailing or support, because all of the city council individuals that won, or when they were ahead and they knew they were going to win, they started denouncing them. But they didn't have a problem having these negative ads that really destroyed and put bad blood in a council race in my district, because after the council person that won will definitely not uphold the democratic process when they do come before them. And all of the unions that do on this particular one, Jobs for New York, they all supported the same individual, and they were sponsored, and even the hotel industry, and they do come up before the council, before state legislators, and it's almost like getting around play to play. It's still the same thing. It's the
So
same.
I think we
same-
wholeheartedly agree. That's why we feel like the disclosure is one important part of the way forward. I will say here in a sort of humorous way that it did occur to me that it's only a matter of time before an independent expenditure seeks to defeat a candidate by bad spending on that candidate's behalf. And so, yeah.
See the 1972 election.
Yeah.
Dirty tricks, Donald Segretti.
Okay. I also just want to remind everyone who's here and everyone who's on the, listening online, that all the written testimony that's been submitted, it will be available on our website. And just in particular, I want to point out that one of the pieces of written testimony that we received was from somebody from Jobs for New York. So I just wanted to mention that.
Can I add one quick thing? I just want to offer, as a spender and a campaign person, and just offer to come in and talk with the staff about better ways to fix the website and do whatever I can to make sure that the program is stronger and better next time around. I prefer not always having conversations in public, being recorded, but I'd love to come and talk to all of you about ways that we can move forward in a positive and productive way. But thank you very much for having this testimony.
And just one thing I forgot
Sure.
to mention for people that want to see the rogues gallery, in addition to all the good data that that the board has put together, if you go to toxictodemocracy.tumblr.com, we assembled something of a rogues gallery of the worst mail sent by independent spenders during this cycle, and it's worth your perusal.
So many thanks to all of you
Thank
for
you
helping
so
us shed
much.
some light.
Excellent.
And we'll hear some testimony.